Thank you, Mr. Vice President. Excellency, colleagues, it is a pleasure to introduce 15 written reports of the Secretary General and the High Commissioner for Human Rights on a range of thematic issues to be considered under Item 3 and Item 8. The first report I would like to present is the consolidated report of the Secretary General and the High Commissioner on the right to development, A/HRC/57/24. It contains analysis of efforts undertaken in the promotion and realization of the right to development in the context of the response to and recovery from the COVID-19 pandemic, and of the reform of the international financial architecture. The report also contains an overview of the activities undertaken by OHCHR from May 23 to May 24 on the promotion and realization of the right to development. The report recommends that Member States and other relevant stakeholders take specific steps towards reforming the international financial architecture to make it more resilient, equitable, and accessible to all, and to better support the realization of human rights. It notes that such reform must be consistent with the right to development. Recognizing that fairer global economic governance structures can enhance legitimacy, strengthening the voices and representation of developing countries in global financial institutions, coupled with more democratic and representative decision-making rules, is essential. Moreover, all stakeholders, including young people, should have the opportunity to participate actively, freely, and meaningfully. The reform of international financial architecture involves reforming the international financial institutions themselves. They should include human rights principles and responsibilities in risk analysis and due diligence processes, and systematically conduct human rights impact assessment integrated with or alongside environmental and social impact assessments. They should also consider states' human rights obligations in their loan agreements, policy advice, and debt sustainability assessments, and at all stages of debt restructuring. The report calls for scaled-up access to timely, concessional, and low-cost financial resources for developing countries, increasing grants to countries with the greatest need and the lowest capacities to mobilize other sources of development finance is particularly urgent. The report further recommends resolving the debt crisis and establishing a fairer, more effective process for restructuring unsustainable sovereign debt in a way that reflects states' international human rights obligations. I would now like to turn to the report of the High Commissioner on the rights of indigenous peoples, mandated by the Human Rights Council Resolution 54/12. The report contains an account of challenges faced by indigenous peoples based on recent developments in human rights bodies and mechanisms. The report also described activities undertaken by OHCHR at the country, regional, and global levels that contributed to the realization of the UN Declaration on the Rights of Indigenous Peoples. Challenges observed include obstacles faced by indigenous peoples in accessing economic, social, and cultural rights, violations of their right to free, prior, and informed consent, limited enjoyment of land rights, and violations of the right to a clean, healthy, and sustainable environment, amongst others. Attacks and reprisals against indigenous human rights defenders have continued. Based on data compiled by OHCHR, at least 42 indigenous human rights defenders were killed in 2023 in 11 countries, a figure that likely understates the total due to underreporting. discrimination against indigenous women and girls, and limited access to education, healthcare, employment, justice, and sexual and reproductive health and rights were also highlighted as a matter of concern. The report calls for renewed commitment by states to adopt comprehensive national strategies to implement the Declaration on the Rights of Indigenous Peoples. The report also recommends states to support the participation of indigenous people representatives in the work of the United Nations, including through the process aimed at enhancing their participation in the work of this Council. While this process is currently ongoing, I would like to recognize that for the first time since the establishment of this Council, indigenous peoples are able to participate in part of this session as such, without the need to be associated to NGO in consultative status with ECOSOC. We welcome this increased participation and hope it is maintained and expanded in future sessions of the Council. I would also like to introduce to you OHCHR's report on procedures on the participation of indigenous peoples at the United Nations and highlighting existing gaps and good practices. A/HRC/57/35. The report takes stock of and compiles existing procedures on indigenous peoples' participation at the United Nations. The report identifies gaps and good practices on the matter. The report concludes that indigenous peoples' participation at the United Nations enhances global decision-making by incorporating their unique knowledge and experiences, contributing to efforts to find solutions for global crises such as climate change. Indigenous peoples' engagement at the United Nations has also advanced their rights, such as through the adoption of the United Nations Declaration on the Rights of Indigenous Peoples and the establishment of relevant mechanisms. Still, challenges remain. Financial support, though available, is insufficient to meet demand. Member States are encouraged to consider establishing an accreditation mechanism to enhance indigenous people participation, increase funding, prevent intimidation, and facilitate visa processes. The report recommends the Human Rights Council and other UN bodies to create structures to support indigenous people's participation without requiring ECOSOC consultative status. Next, I would like to present the Secretary General's report, yearly supplement to the quinquennial report on capital punishment and the implementation of safeguards guaranteeing protection on the rights of those facing the death penalty. This is report A/HRC 5726. This report was submitted to update previous reports on the question of the death penalty. Pursuant to Council Resolution 22/11, it also includes information on the human rights of children of parents sentenced to the death penalty or executed. In the report, the Secretary General again recognizes the general trend towards universal abolition of the death penalty and highlights initiatives limiting its use and implementing safeguards guaranteeing the protection of the rights of those facing this penalty. Despite the continuous decrease in the number of countries carrying out executions, between July 2022 and June 2024, there was a steady increase in the numbers of people known to have been executed worldwide. This reflects a worrying global trend whereby a diminishing number of retentionist countries are substantially increasing the number of executions they conduct. The International Covenant on Civil and Political Rights provides that states should impose the death penalty only for the most serious crimes. The Human Rights Committee and the Secretary General have indicated that this term must be read restrictively and appertain only to crimes of extreme gravity involving intentional killing. Crimes not resulting directly and intentionally in death, such as drug-related offenses, can never serve as the basis for the imposition of the death penalty within the framework of the right to life. Nevertheless, there has been a considerable increase in executions for drug-related offenses over the past 2 years. Drug-related offenses were responsible for roughly 42% of all executions confirmed globally in 2023, the highest recorded figure since 2016. The report concludes with a series of additional recommendations to states to accelerate progress towards universal abolition and on other subjects, including the need to ensure a protective environment for the children of parents sentenced to death or executed, including preventing discrimination, stigmatization, and distress, and to provide them with assistance based on the principle of the best interest of the child. I would now like to present to you a study prepared by the Office of the High Commissioner of Human Rights on the role of the rule of law and accountability on the national and international levels in the prevention of human rights violations and abuses. A/HRC/57/27. The rule of law and accountability play crucial roles in the prevention of human rights violations and abuses. The rule of law is central to strengthening the capacity of the state to respect and protect human rights, and accountability is essential to prevent impunity and the recurrence of violations and abuses. The report examines and issues recommendations with respect to the following 5 elements of the rule of law at the national level. First, limiting the arbitrary exercise of public power. Second, requiring accountability for the exercise of public power. Third, ensuring transparency of public institutions. Fourth, promoting participation in public decision-making. And 5, ensuring access to justice. The report also notes the preventive role of public institutions in ensuring effective oversight over the executive branch of governments and the importance of the rule of law within the executive branch, particularly the security sector. At the international level, rule of law requires compliance with international law, which is essential for the maintenance of international peace and security and ultimately to protect individuals. In this regard, the report highlights and issues recommendations with respect to the codification, interpretation, and progressive development of international law, the peaceful settlement of disputes before independent legal bodies, and access to international justice for individuals. With respect to accountability, the report notes the diversification of venues in which criminal accountability for human rights crimes may be pursued and examines the issues and issues recommendations related to the investigation, prosecution, and punishment of international crimes by states, including third states exercising universal jurisdiction. Importantly, it recognizes the crucial role that civil society plays in all accountability efforts. Lastly, the report notes the important role that accountability mechanisms play in supporting the investigation and prosecution of serious human rights violations and abuses. It provides recommendations to strengthen cooperation and support for such mechanisms, as well as for civil society. Next, I would like to draw your attention to the High Commissioner's study on solutions to promote digital education for young people and to ensure their protection from online threats. A/HRC/57/28. The report addresses this topic, focusing particularly on those facing intersecting forms of discrimination and in vulnerable situations. It highlights systemic and structural barriers states face in meeting their human rights obligations and ensuring youth can access digital education and realize their human rights online in a safe, inclusive, and empowering manner. Youth are the most connected age group, with 79% of people aged 15 to 24 using the internet in 2023. Yet, youth worldwide are frequently not able to access the infrastructure, devices, or knowledge required to navigate online safely. For example, globally, 2.2 billion individuals under age 25 lack internet access at home. The report identifies barriers limiting access to digital education. These include a lack of equal access to computers, laptops, tablets, and smartphones, reliable and affordable electricity, as well as internet coverage and connectivity, and a lack of digital media information literacy skill, as well as cultural and linguistic barriers. These barriers exacerbate existing educational and social inequalities and limit the ability of young people to realize their rights, such as the rights to education, participation, freedom of expression, information, livelihood, privacy, and non-discrimination. Digital space have broadened young people's horizons. Yet, given the gaps noted above, digital spaces also pose threats to young people's safety and well-being. Such threats include cyberbullying, harassment, intimidation, hate speech, abuse, and violence. Such harmful behaviors negatively affect young people's rights to privacy, participation, and freedom of expression, and mental health. The study emphasizes that a youth rights-based approach is essential to realize youth rights online in a safe, empowering, and inclusive manner. It demonstrates that digital education, including digital, media, and information literacy, and human rights education, is integral to youth rights and their full participation in society. The study recommends that states adopt a youth-centered, human rights-based approach to youth rights online, and that they implement it in partnership with young people, detailing the key steps in such an approach. Next, I would like to draw your attention to the report of the High Commission on Terrorism and Human Rights, A/HRC/57/29. It notes that terrorism remains a substantial threat to international peace and security, and studies the growing trend among states to employ administrative measures outside the confines of the criminal justice process to address terrorism, such as detention without trial, travel restriction, and deprivation of nationality. The report recognizes that such measures are aimed at enhancing security, while raising concerns about those approaches and how they are implemented. Certain administrative measures tend to resemble criminal sanctions, with far-reaching restrictions on rights, including the rights to liberty, security, free expression, and peaceful assembly. However, these measures often lack the procedural safeguards applied in a criminal law setting. The report also details concerns about the transparency, use of secret information, and low evidentiary threshold employed to justify various forms of administrative control over individuals not formally charged for terrorism-related offenses. The report concludes that administrative measures should not be used as a tool to bypass the constraints of criminal law. It is crucial for states to ensure that any administrative measures that resemble criminal sanctions are subject to rigorous procedural guarantees, transparency, and independent judicial oversight, tantamount to those applicable to criminal measures. Such an approach helps to ensure that such measures are applied fairly, lawfully, and in a manner that respects international human rights standards. The report also provides a series of recommendations to UN entities to promote the compliance with human rights as an integral part of their assistance to states in the development and implementation of counter-terrorism administrative measures. I would now like to present the report of the High Commissioner on challenges and best practices in regularly assessing civic space trends and recommendations with a view to enhancing information gathering on civic space, A/HRC/57/31. Recognizing that compelling data on civic space trends is key for effective human rights interventions, the report gives an overview of the three overarching approaches to assessing civic space that are often used in combination. First, assessing the legal and policy framework and distilling trends from there. Second, focusing on events relevant to civic space, such as specific incidents and restrictions in relation to the freedoms of expression, association, and assembly. And third, surveying the perceptions of the public or expert of civic space trends. It goes on to explore the contributions of different actors to understanding civic space trends, stressing the critical role of people who collect information on the ground and observing that they often face risks for doing so. The report also points to other key challenges, such as barriers limiting access to information, including information from judicial and administrative bodies, and at the local level. Furthermore, the report notes that inconsistencies in terminology and methodologies often hinder comparison across geographies and over time. As online civic space has become increasingly more important, assessing trends relating to people's ability to exercise their right to participate and their freedoms online has become critical. Yet, tools and approaches for assessing civil space online are still limited and need further development. In conclusion, the report emphasizes that collecting timely and disaggregated data is vital not only for advancing human rights, but also peace and development. The High Commission calls on states and other actors to increase access to relevant data to ensure that contributors to civic space assessments on the ground can do their work safely, and recommends stepping up work on assessing trends relative to online civic space. Next, I would like to draw your attention to a compilation of best practices in the contribution of development to the promotion and protection of all human rights in the context of recovery from the coronavirus disease pandemic, A/HRC/57/33. The report notes that countries continue to experience the lingering impacts of the COVID-19 pandemic. Moreover, that and climate vulnerable countries are particularly hard hit by the polycrisis that the world is facing. Recognizing that development and human rights are interdependent and mutually reinforcing, the report explores promising practices to tackle rising poverty and inequalities and to leave no one behind. It highlights the value of placing human rights at the heart of economic policy when austerity measures and social spending cuts are being considered. It also discusses the role of essential tools of governance, such as national development plans, public finance, and debt management frameworks. Such tools can help ring-fence economic, social, and other rights, including the right to development and reverse SDG backsliding. Examples contained in the report showcase the value of greater transparency in the context of debt management, access to information, and accountability in the design of emergency measures, economic policy, and long-term national development plans. The report emphasizes that these measures are most effective when coupled with meaningful public participation and civic space that promotes a state's ability to meet its human rights obligations. It further highlights the importance of using human rights impact assessments in the context of sovereign debt restructuring. Reforms in debt sustainability and credit risk assessment should give prominence to human rights, the SDGs, and climate-related commitments. Finally, as countries continue to experience chronic delays in restructuring their sovereign debt, the report reiterates the global call to move towards a multilateral legal framework on sovereign debt that places human rights and the 2030 Agenda for Sustainable Development at its center. The report also notes that the Summit of the Future, to be held in a few days, and the 4th International Conference on Financing for Development in 2025 provide historic opportunities for much-needed systemic reform. Next, I would like to present OHCHR report on the plan of action for the 5th phase of the World Programme for Human Rights Education 2025 to 2029. A/HRC/57/34. As decided by the Council, the 5th phase focuses on human rights education for children and youth with special emphasis on 3 thematic areas: human rights and digital technologies, the environment and climate change, and gender equality. The plan of action provides related guidance to develop a comprehensive human rights education strategy for children and youth at the national level, in formal and non-formal education, involving 4 components. A, policies and related implementation measures. B, teaching and learning processes and tools. C, training of educators. And D, an enabling environment. With regard to teaching content, the plan of action highlights specific competencies that human rights education should foster in the 3 highlighted thematic areas named earlier. The plan of action draws upon relevant United Nations instruments and documents, materials, and United Nations initiatives involving or led by children and young people. It benefited from inputs from a large group of stakeholders gathered through broad consultations. I would now like to introduce OHCHR report on the impact of climate change on the equal enjoyment of the right to education by every girl, A/HRC/57/37, which falls under item 8 of the Council's agenda. The report's analysis focuses on 3 dimensions of the right to education: the right of access to education, rights within education, and how the enjoyment of human rights can be achieved through education. The main findings of the reports are as follows. First, in the context of climate change, challenges faced by girls in their enjoyment of the right to education often results from multiple and interlinked factors, such as climate-induced displacement, child, early and forced marriages, gender-based violence, including sexual violence, the lack of essential facilities and infrastructure to meet the needs of girls and young women, a lack of security, entrenched gender stereotypes affecting the representation of girls in science, technology, engineering, and maths. And finally, the underrepresentation of women and girls in political decision-making processes. Second, education can help girls to identify climate change risks and hazards and enhance their resilience against those risks. Education can also empower girls with skills, knowledge, competencies, and behaviors to respond to the causes of climate change and environmental degradation. Third, international cooperation is critical. Developing countries need greater financial resources to prevent, minimize, and address adverse climate impacts on girls' education. In discharging their obligation towards the rights to education and to establishing adaptation measures for and mitigating the effects of climate change, states should also be guided by the principles of equity and their common but differentiated responsibilities and capabilities in light of different national circumstances. Allow me now to draw your attention to the report of the Secretary General on national institutions for the promotion and protection of human rights, A/HRC/57/65. It provides an overview of the activities of OHCHR and other UN entities to support member states in the establishment and strengthening of national human rights institutions, NHRIs, through advisory services, technical cooperation, and capacity building programs. The report also discusses the collaboration between NHRIs and the international human rights system and showcases best practices amongst NHRIs in promoting and protecting human rights at the national level. Additionally, the report outlines the Office's contribution to global and regional NHRIs networks, including its role in the accreditation process. The report calls on member states to establish NHRIs by aligning them with the Paris Principles and protecting their independence, and to provide financial resources to support the work of OHCHR, particularly its technical cooperation programs on HRIs and fellowship program for staff of A-status NHRIs. It also calls for protection of NHRI members and staff from reprisals and encourages their continued engagement with international human rights mechanisms. The next report I would like to present is the report of the Secretary General on activities of the Global Alliance of National Human Rights Institutions in accrediting national institutions, A/HRC/57/66. It provides an overview of the activities of the Subcommittee on Accreditation of Global Alliances of National Human Rights Institution, GANRI, and OHCHR as its Secretariat. It highlights key developments and improvements in the accreditation process since 2022, including the number of accredited NHRIs and the extension of the Subcommittee on Accreditation's working hours from 1 to 2 weeks to enhance efficiency. The report notes that 118 national human rights institutions are accredited, with 90 fully compliant A status and 28 partially compliant B status, representing 88 United Nations member and observer states. To meet SDG indicator 16.A.1, by 2030, the report urges states to ensure the existence of independent NHRIs in line with the Paris Principles and recommends seeking OHCHR assistance for drafting laws, establishing, strengthening, and achieving accreditation for national institutions. The report calls for increased financial support to OHCHR, which is the Secretariat of the Subcommittee on Accreditation, to ensure inclusivity and fairness. The report further emphasizes that OHCHR roles in the Subcommittee on Accreditation is key to ensuring the credibility of the accreditation process. In closing, I would like to briefly draw your attention to 3 summary reports. First, I would like to present the summary report on the intersessional panel on avenues to prevent and address human rights violations and abuses against migrants in transit, including through monitoring at international borders, A/HRC/57/32. The panel discussion held on 15 May 2024 emphasized the importance of addressing migration within the agenda of the Human Rights Council and recalled the vital role played by the Council and its mechanisms in preventing human rights violations and ensuring accountability for violations and abuses that migrants face in transit and on arrival. Participants recommended reviewing security-driven and deterrence-based migration governance that places migrants in transit at greater risk, and countering harmful and dehumanizing narratives which contribute to the acceptance of human harm along migration routes. They also recommended expanding pathways for safe and regular migration, including regularization as means of preventing and addressing situation vulnerability across migratory routes. I would like now to introduce the summary report on the expert meeting on the human rights obligations of states regarding violence against and abuse and neglect of older people in all settings. During the meeting, the experts highlighted ageism as the root cause of violence, abuse, and neglect of older persons. They discussed the harmful effects of social exclusion and digital divide, and the specific challenges older persons face in various care and support settings. The expert meeting also discussed the structural violence experienced by older persons. Through the meeting, experts shared experience, best practices, and challenges, culminating in several key recommendations to member states. In particular, they called for the creation of new, legally binding international instrument dedicated to the rights of older persons. The final report that I would like to bring to your attention today is the OHCHR summary report on the intersessional panel discussion on the impact of drug-related challenges on the enjoyment of human rights. The panel was held on 5th February 2024. It provides an overview of the specific human rights challenges in addressing and countering all aspects of the world drug problem and to consider the implementation of key recommendations highlighted in the report. Participants highlighted the importance of placing human rights at the center of all policies that tackle the world drug problem and recommend to infuse a human rights dimension into all forums where these issues were addressed. In this regard, the participant welcomed the Office's report on this topic submitted to the Council in September 2023. They recommended to implement gender-sensitive drug policies that responded to the specific needs of women and age-specific programs for children who are particularly vulnerable to the negative health and social consequences of substance and drug use. The panel also encouraged the Human Rights Council to continue its engagement on the topics related to world drug situation. This concludes the presentation of the 15 reports. Thank you for your attention.